Who's on the device named Terry's Galaxy?
I am
What's your name?
Terry Reed.
Thank you. Okay. Ms. Till, how are you?
I'm good, Your Honor, and yourself?
Hanging in there. I have a hefty file of paperwork though that I need to review, so
Take
a
your
little
time.
overwhelmed. Let's see here. What, you're here for DeAndre Terry?
Yeah, Denotre Terry. I don't believe I see plaintiff's counsel. But I
In the
do.
courtroom.
She is in the courtroom. Okay.
Correct.
But I have not spoken to
Did
my
you file an
client.
appearance?
I believe I did, Your Honor, but it may have been only in the NPR file. I can file it one in this case as well.
Okay, we don't have you listed, so you do need to speak to plaintiff's counsel.
If I could, is the defendant in the room, in the courtroom?
No, Your Honor.
DeAndre Terry is not present, no.
Okay, if I could speak to her in a breakout, if I could speak to plaintiff's counsel in a breakout room, that would be
Do you
great.
have a cell phone with you?
I did not.
Okay, no worries. We have an iPad, so once it's available, we'll get you on our iPad.
Great, thank you.
No problem. Okay, we'll get her in a room in just a moment. And let's see, what's Mr. Arambola is here for this one. What else here? What did we do? What did you do? We didn't have a lot of marks. Okay, he's here on that one. What did you say his last name was? I don't see him either. Terry's Galaxy, can you, Rivers maybe? No. Can you give me your file number? I'm sorry, Ms. Till, I didn't mean to do that. That was an accident.
Perfect. Sorry, Your Honor.
Terry's Galaxy, you're muted. Can you unmute, please?
There you go.
Okay, what's your case number?
I'm not representing. I'm just here as a witness. That was the counsel record is Todd Bronson.
Okay, you're here on Twin Oaks Meadows, that matter?
That's correct.
Okay, and you're a witness in what capacity?
I was the property manager.
Okay, thank you. Okay, got you renamed. So you know who you are. Cool. Sean Mott is here.
Yes, thank you, Your Honor.
Okay, Mr. Rambola logged back off, but I think he's logging in again now. Let's see.
And I am here as well for that case.
You're here. You are Anna?
I'm Alicia, yes.
Okay. You have a device that you can log into Zoom with at all, ma'am?
I'm sorry.
Did you have an electronic device with you in case you need to speak with Mr. March privately?
Yes, I do.
Okay, Mr. March, did you all have an opportunity to discuss this matter privately?
We have not. I'm
Today?
happy to do so.
Okay, if you can log into Zoom, I'll get you all into a private meeting room.
Do you want me to go out there?
Yes, you should go out there. Do we have a room? But then, yeah, I know Bigelow's in one of them. Yeah, let's see if we can find you a private meeting room because there's a jury in that room.
Okay, thank you.
Patricia Lewis is here. I don't see an attorney here yet on that matter. What's your name?
Tiara Rivers.
Okay, 2:30, gotcha. Okay, Miss Donnelly appears to be back. Okay, you left the iPad in there for them?
I did.
Okay, perfect. I will put Ms. Till in the room with them. Let's see. Ms. Till, I'm gonna put you in room 1.
Thank you, Your Honor.
No problem. Okay, we're on the record in the matter of the people of this. This should be City of Lansing. City of Lansing versus Jordan Bonds, file number 22-03474. Council appearance.
Matt Staples for the City of Lansing.
Behalf of the defendant, Jordan Bonds, who is appearing in person.
Thank you. Today was a date set for a pre-trial on a no ops. How are we proceeding, counsel?
Your Honor, Assistant Public Defender John Lee is the attorney of record. He communicated with Mr. Staples, who agreed to have an added or amended count of allowing a suspended person to operate, and Mr. Bonds would like to accept that offer.
Is that correct? You want to plead to the amended charge of allowing a suspended person to operate?
Yes, ma'am.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Okay, you can put your hand down. Mr. Bonds, you have the following rights that you would need to waive if you wanted to accept the offer to enter a plea to the amended charge. First, you have the right to a trial. You have the right to a jury trial. At the time of trial, you have the right to the presumption of innocence. So you're innocent until proven guilty. You have the right to have the city prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt at a trial. You have the right to see, hear, or question any other witnesses and cross-examine any witness the prosecution intends to call. You have the right to call your own witnesses to trial or present evidence at trial that you believe further the defense to the charge being brought against you. And you have the right to remain silent at trial and not have silence be used against you. Do you understand that?
Yes.
Are you willing to waive all of those rights today in order to plead guilty to the amended count of allowing a suspended person to operate a motor vehicle?
Yes.
Anybody threatening you to get you to waive your rights and plead guilty?
No.
Any promises being made in exchange for a guilty plea today?
No.
Are you entering a plea because you believe you're guilty?
Yes.
As to the amended charge of allowing a suspended person to operate, are you pleading guilty, not guilty, or standing mute?
Guilty.
Can I have a factual basis, counsel?
Thank you, Your Honor. Mr. Bonds, on December 7th of 2022, were you operating a vehicle upon a public highway, that being Pennsylvania Avenue at or near Haco in the city of Lansing, Ingham County, state of Michigan?
Yes.
And at that time and place while you were operating that vehicle, did you have a valid license on you?
No,
And to this day, or at this moment, do you have a valid license?
no.
Your Honor, I have no further questions.
Any questions from the city?
Nothing from the city, Your Honor.
Court is satisfied with the factual basis. I'll accept your plea. Find your plea to be made freely, voluntarily, and intelligently. Looks like you were arraigned on this, at least on the bench warrant, back on May 19th. You were given a 10% bond. I'll credit you time, sir. You're all set.
All right, thank you.
You're welcome. Okay. Thank you, Ms. Donnelly. Thank you, Mr. Staples.
Thank you, Your Honor.
See. That took care of all of our criminal. Okay. There's a lot going on right now. Someone named Jackie. Is that Jackie? Sean? Okay, very good. Okay. Mr. March, are you ready with your matter?
I am, Your Honor. After speaking, it does not appear we'll be able to reach an agreement, and the plaintiff is ready to move forward with proofs at a hearing, Your Honor.
Okay, sounds good.
Hi.
Oh,
Hi.
are you driving?
Yeah, I'm pulling over right now. I'm just leaving work.
Okay, well, I'm putting you out right now too. You call back when you're not driving. Okay. Ms. Till, are you ready on your matter?
We are, Your Honor.
Okay, we're on the record in the matter of Fox Land Holdings LLC versus Denosha Terry. File number is 23-00593 LT. Appearance for the record, please.
Good afternoon, Your Honor. Rhonda Kunkel appearing on behalf of the plaintiff, Fox Land Holdings, and Mary Jo Schmidt is here to my left.
Thank you. Today was the date set for a hearing on a termination of tenancy. The plaintiff is present, represented by counsel. The defendant is not present, I don't believe, but the counsel for the defendant is present. Parties, how are you going to proceed?
Your Honor, today we are entering a default judgment with an eviction date of 6/23/2023. There is no money judgment at this time.
Okay, default judgment will enter at this time. Any additional matters for the record?
No, Your Honor.
Nothing for defendant, Your Honor.
Thank you. You're all set.
Thank you.
You have your default paperwork with you? Okay, you can approach. Thank you. Yeah, default thing too. Okay, we need one other document completed. When Mr. Bigelow come back, he'll give it to you.
The default?
Mhm.
Sorry.
Oh, okay.
I have that.
You.
Thank you.
I don't see where Ms. Johnson made it in. I do see Patricia Lewis. Can you hear me? Oh, gosh. Ms. Lewis has been here all this time, no audio. Zoom life. It's just wonderful.
I have no idea why this is not working.
Okay, we can hear you.
Yeah, now. Okay, I'm sorry.
No, no worries.
Judge Simmons.
Oh, great.
Good
Yes,
afternoon.
we can.
Good afternoon.
Thank you, ma'am. Okay. Do you have an attorney, ma'am?
No, ma'am.
I'm sorry, Miss Johnson. I'm talking to Miss Lewis. I was asking her if she had an attorney.
No,
Miss Lewis. Okay, very good. I don't know what happened to your video, Miss Lewis.
I don't know either. I'm lost on this. Okay, let's see, get this right.
Okay, we are on the record in the matter of Cedar Place Apartments versus Patricia Lewis, file number 23-00446 LTE, counsel appearance.
Good afternoon, Judge Christopher Asphalt, 53129 on behalf of the plaintiff.
Okay, thank you. And then Ms. Lewis is present via Zoom without
Yes,
representation by counsel. Today was the date that was set for a motion to set aside default judgment. You filed a motion on the 31st of May after missing court back on May 24th. You indicated that you missed court because of the death of your son, and you ended up forgetting your court date.
yes.
That's accurate, ma'am?
Yes, yes.
Okay, and so you want the default set aside so we can set it for a hearing?
Yes.
Okay, Mr. Asphalt?
Your Honor, I don't necessarily think she's shown good cause, and I certainly don't think she's shown a meritorious defense either. So I would request that the motion be denied and the default judgment stand. With that being said, I am willing to talk with her if she wants to enter into some type of payment plan.
Okay.
Yeah.
You don't believe her the death of her son was good cause to miss court?
Well, that's why I said not necessarily. I was putting more emphasis on the meritorious defense part of it, Your Honor.
Oh, okay. I'm gonna grant her request because she had extenuating circumstances as to why she missed court. And I'll set aside the default, set it for a hearing.
Judge, would you consider an escrow order? Although I haven't heard the return date. If it's not that far out, it won't be necessary.
She's already has an escrow. It's already an escrow. She did it when she filed the motion.
Oh, she's paying it to the court?
She has paid into the court.
Okay, so that will continue then. All right, very good.
Then we're gonna do a hearing on this one. Do July 26th. Hearing's gonna be July 26th at 2:00.
Your Honor, could you just verify like how much is the escrow order for and when is she supposed to make payments?
She made a payment on the 31st of $703.
On the 31st of, I couldn't hear that, Your Honor.
The 31st of May, yes.
Okay, and so then she'll continue to make payments at the last day of the month until the
I
hearing?
don't see that there was a continuing order. You can file a motion if you want that to continue.
Very good.
Okay, what time is the hearing again? At 2 p.m. Okay, so again, the hearing is gonna be July 26th at 2 p.m. And then, Mr. Asphalt, we should expect a motion for escrow order to enter, correct?
It may be forthcoming, Judge, yes.
Sounds good. Any additional matters for the record?
No.
Okay, if you still want to be put in a private meeting room, I can do that. Ms. Lewis, you were already advised of your right to be represented by counsel at your pretrial. And so You did not appear with counsel today. Are you not seeking to be represented by counsel, ma'am?
I would like to have counsel.
Okay, did you meet with legal services?
No, it wasn't legal services. No, I didn't.
You did not when you were here previously?
This is my first time. Well, this is the first time I've been seen by your court officer today.
Today, but you were here back on April 12th.
Okay.
Do you recall that?
Yes, I did it over Zoom. Yes.
And did you meet with legal services then?
No.
Okay, Ms. Till was just here. We'll see if she can log in. Because if you were denied their representation, then you would need to hire your own attorney, but I don't know if you did an intake. Can you see if Ms. Till can log back in, please? Hang tight, Ms. Lewis, and we'll get Ms. Till to log back in if she's available. Okay, I did see Jacqueline Johnson.
And John Bradshaw on behalf of the plaintiff, Your Honor.
Ms. Johnson, can you unmute your device?
Can you hear me now?
I can hear you. We're on the record in HZ CNAC Inc. versus Jacqueline Johnson. File number is 21-02772. Counsel appearance.
John Bradshaw on behalf of the plaintiff, Your Honor.
Okay, and then Ms. Johnson, you're not represented by counsel, correct?
No, correct.
Okay, today was the date that we set for review. You were here back on December 5th. And at the time you were only working 4 hours a day, and the court granted your request to pay $50 every 2 weeks beginning February 1st. And so looks like you're seeking to continue to make those payments or make payments of $50 every 2 weeks starting the.
So
okay, what is your?
If it pleases the court, Your Honor, I think we're here on a couple of things that in between then and now, the defendant did make 2 payments in February. She didn't make any payments after those 2 payments in February. And then I believe our office moved to set aside that installment payment order. And I believe that order was set aside in late May or early June. Now, in the meantime, the defendant again has filed for an installment payment order, and that's probably what you're looking at right now, again, for the same amount, 50 biweekly. And we've responded to that saying a couple of things. One, that she didn't comply with the previous one. She did call to say that she would try to make up some payments, and she did make 1 payment, but she hasn't made so anywhere near what she should. Anywhere.
Well, I only have this set for a review, which is what my note said from December.
Great. Okay, so I would ask that, I think this has been set aside, and so if not, if you're not seeing that, because I know we did a motion for it, then I would request it be set aside, and then I can continue on with the garnishment, because I have received 1 garnishment in the meantime, unless Ms. Johnson, you agreed to 100 biweekly, and then I'm good with that. It's splitting the difference, and
okay,
we're good.
Okay,
everybody's gonna calm down. Everybody's gonna calm down. Everybody's gonna calm down, because this is not a back and forth conversation between the two or you all. You're talking to me.
I'm sorry.
I'm first gonna address what we're here for. And so you're claiming that you said you filed a motion to set aside the installment order, Mr. Bradshaw, or someone from your office did?
Yes, and I believe that an order was signed on 5/26/23.
Okay, I just see that it wasn't set for a hearing. We wouldn't have a hearing for that. When that happened, you are correct. I did see that in here. Then this review would have, or should have, I guess, been removed from the docket. And maybe that was likely the case. I'm not sure. I have that I had set this review for June 6th, but maybe we moved it. Is that what happened? Was I here on June 6th? Okay, it might have been moved because I had June 6th off and was supposed to have it off. And so it got moved to this date. So whenever she filed this motion to set aside, or a motion for order for a new installment payment, it had not yet been calendared. So that's why it's not on my docket for today. So that brings us up to speed. Let's see. And so you said she made 2 payments and then she did not make any further payments. That's correct, Ms. Johnson?
Yes, I called into the office though, after I made my payments in February, like I believe it was, I got a date written down. It was like March 3rd. My mom took like a very bad health like scare and she was in the hospital for like a few weeks. I had to take off a month of work to go down there to take after care of my sick mom. I did call his office in the meantime and let them know that I did take the time off work and that I'm able to go back into resuming my payments. Last week, I made a payment of $150. I get my next check in 2 weeks, and I said that I will be okay with like catching up with the remaining balance that I did pay. But right now, I'm just getting started back work. This is like my 3rd day back. So the lady told me that will be fine. They had already put in a request for garnishment. I did go to the court to try to stop that, but she said that he wanted to resume forward with a court case. So I guess that's what we're finishing up here.
Okay, sounds good. So Mr. Bradshaw, you said you would entertain talking to her to come up with a new payment plan?
Yes, ma'am. Yes, Your Honor.
Okay, very good. We'll put you in the private meeting room.
Okay.
Bye.
Your Honor, I'm sorry to interrupt. Am I okay to log off at this point?
Oh, well, if you want to hang tight, I just wanted to see from Ms. Till, she just logged in. Ms. Lewis is present, Patricia Lewis. She can't recall if she did an intake with your office previously.
Okay, let me just take a look in our system to make sure we don't already have an intake. Just give me 1 second.
Because if she's not going to be represented and she's going to waive her right, then she can meet with Mr. Asphalt today, but otherwise.
Okay. So,
she needs to do an intake.
Okay, perfect. Your Honor, I do not have an intake for Ms. Lewis in our system.
Okay, can I put her in a private meeting room with you? In which case, Mr. Asphalt, I guess you can meet with her at the next court date.
Okay. Maybe Felicity, if you wouldn't mind, could you email me when you're through to let me know if you're representing her? And if not, maybe I'll just reach out to her directly. Thank you, Judge.
Yes, I'll try to let you know one way or the other.
Okay.
Perfect.
Have a good day.
Thank you. Same to you. Okay, I'm gonna put Ms. Lewis in room 3 and then Ms. Till, I'll put you in room 3.
Perfect. Thank you, Your Honor.
Thank you. Okay. Moving to the next one. That was Lewis. Okay. No, which matter? Which matter is, okay, he's on that matter. He's the landlord. Stop. Okay, that's too much. Okay, Werner is on which matter? Jessica Werner?
Yes, good afternoon.
Good afternoon. Which matter are you here for?
I'm here for the case ending in 721. LG Lansing versus Davis.
Okay, sounds good. We're on the record in the matter of Stanley Meyer versus Alejandro Arambula and Ana Gonzalez Arambula. File number 23-00618 SP, council appearance.
Yeah, good afternoon, Your Honor. Attorney Sean Mock on behalf of Stanley Meyer, who is also present on the Zoom call.
Okay, and ma'am, I'm not butchering your name or anything. That's just what it was on my docket. So I'm just reading what's there, but you can state your name for the record.
My name is Annalicia Arambula.
Very good. And then we have Alejandro Arambula. Can you hear us, sir?
Ma'am,
Okay, give me just a moment. Someone's in my waiting room. Let me see if they're prepared for court. Wow, magically, you'd be able to share it this time. Okay, today's the date and time that's set for a hearing. You can have a seat, ma'am. On a land contract forfeiture, the parties were unable to come to resolution. Mr. Mark, you can proceed.
Thank you, Your Honor. I would call Mr. Stanley Meyer as witness.
Mr. Meyer, can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
I do, Your Honor.
Okay, thank you. You can proceed, counsel.
Thank you, Your Honor. Hi, Mr. Meyer. Do you own legal title to the property known as 1118 Ballard Street in Lansing, Michigan?
Yes.
And at some point in time, did you engage with the defendants, Mr. and Mrs. Arambula, to enter into a land contract for the sale of this property?
Yes.
Okay. Your Honor, would it be possible to enable screen sharing?
Just a moment. I may have to make you co-host. We had to disable screen sharing because we've been having issues in the virtual courtroom. So I'll make you co-host. I'm not gonna disable. I'm not gonna disable you. I'm just gonna make you co-host. I don't want nobody else to share. Okay. You should have the ability to share now.
Yes, I do. Thank you. Okay, Mr. Meyer, can you see my screen?
Yes.
Okay, on the screen is a document titled Contract for Deed. Let me scroll through this document slowly. And here, when we get to page 5, is that your signature that appears on this document?
Yes. Yes, it is.
And you signed this on October 15th of 2020, is that correct?
Correct.
And the document also reflects the signature of both defendants in this case, is that correct? On the following pages?
Yes.
Okay. So when you and the defendants in this case discussed the sale, the sale of the property, did you reduce those terms to writing?
Reduce, put them into writing, yes.
Okay, and is this the writing, the agreement that you reached to sell the property to the defendants?
Yes.
Okay. And according to this agreement, the purchase price of the property is $80,000, is that correct?
Yes.
Okay. And according to this agreement, the defendants were to make monthly payments of $1,050 beginning November 15th of 2020. Is that correct?
Yes.
All right. And then regarding property taxes and assessments, per the agreement between you and the buyers, you agreed to pay all real estate taxes and assessments levied against the property. Is that correct?
Yes.
However, are the defendants responsible for any assessments that arise out of their use in the property?
Correct.
For example, any fines or other assessments that are levied as a direct result of their use of the property?
Yes, that is correct.
Okay, and that is reflected on this page 3 of this document, correct?
Yes.
Okay. So you and the defendants reviewed this document and agreed to the terms of this document as indicated by your signature on the document?
Yes.
Okay. Your Honor, I would move to admit plaintiff's proposed exhibit 1.
Any objections from the defendants? Yes. You're objecting to the
Yes.
contract?
Yes,
Why? Why is that?
because I have my contract and I actually have a copy for you. And in my contract where they state, well, actually first, look,
So you're disputing this is the contract?
this is the contract because on mine it states 681.
It says
Also-
say 681, what do you mean?
That's what my payment was 681. What I agreed to do was to pay 1050, and that extra payment that I was paying was actually going to, in a sense, as an escrow, because as they said, I am me and my husband are responsible for the interest and principal. And with that additional almost $400.
Okay, well, this is not your time to give testimony. This is the time to give an objection to this
Okay.
being admitted under the rules of evidence.
So yes,
They are objecting. Did you want to respond to the objection?
and I actually.
Counsel.
Objection.
Your Honor, I believe
Okay.
the document has been authenticated and verified, and I would propose the document be admitted.
Thank you. The objection is overruled because that objection is not an objection as to under the rules of evidence if this is inadmissible. But what you have may be evidence that you want admitted when your turn is to present evidence.
Okay.
But as to this is their exhibit.
Okay.
So you don't have to agree with their
Okay,
exhibit.
yeah.
Okay.
Okay.
Okay. So you're stating that this is not, you don't believe this is the accurate exhibit.
And I
Okay.
would also like to say, Mr. Meyer was actually not present when we signed this. It was actually his wife.
Okay. But again,
So
this is
we
not your
had-
time to
Okay.
give that testimony. You got to get all that out when your turn is
Okay.
up, okay? But you should take note so that you know what you want to admit. And you had another objection.
That was the other one. Was
Got
that
it.
was not.
Sounds good. Counsel, you can proceed. Plaintiff's 1 is admitted.
Thank you, Your Honor. Mr. Meyer, have the buyers, the defendants in this case, complied with the terms of this land contract?
For the first 2 years, they did, yes.
Okay. But at some point, they failed to comply with the terms of the contract?
Oh, yes.
Okay. I'm going to show you what I've marked as the, sorry if this is I'm sorry, plaintiff's proposed exhibit 2. Mr. Meyer, did you keep record of all the payments that you received from the defendants under the land contract?
Yes.
Okay, and I'm going to scroll through this document slowly. And my question to you, Mr. Meyer, is, does this document accurately reflect all payments received by the defendants, from the defendants under the land contract?
Yes.
Okay. And the date reflected for each payment is the date that you received that payment?
Correct, yes.
Okay. And these items marked loan at $50, are those late fees that you assessed against the defendants for late payments?
Yes, that's correct.
Okay. So, and then also, does this document labeled actual amortization assess the contractual interest rate of 10% on the principal balance?
Yes.
Okay. So you use this spreadsheet to calculate the current amount due under the land contract. Is that correct?
Yes.
Okay. And if we look at the bottom, after application of all these payments, the addition of any of these late charges. This balance here noted on June 14th of 2023 of $75,640.26. Is that the current principal balance due on the land contract through the monthly period ending June 14th of 2023?
Yes, that is correct.
Okay. Your Honor, I would move to admit the plaintiff's proposed Exhibit 2.
Any objection? There's no objection? Is that from you as well, Mr. Arambula?
Nope.
Okay, plaintiffs 2 is admitted.
Thank you,
You
Your
can
Honor.
proceed.
Now I'm going to show you what's been marked as plaintiff's proposed Exhibit 3. Is this a document that, this document is titled 1118 Ballard Street Expected Amortization? Is this a calculation of the current balance due under the land contract if the defendants had complied with all terms, meaning made timely payments with no late fees under the contract?
Yes, that's correct.
Okay. So according to the land contract terms that we just went over on the plaintiff's Exhibit 1, reflected as the $2,400 down payment, followed by monthly payments of $1,050, correct?
Yes.
And that is, by the terms of the land contract, the payment that the defendants were required to make?
Yes.
Okay. So then at the bottom here, this document reflects, as of the period ending June 14th, 2023, a principal balance of $63,921.28. Mr. Meyer, is this the amount that would be due, the expected amount that would be due under the land contract if all payments had been timely made?
Yes.
Okay. The plaintiff moves to admit the plaintiff's proposed Exhibit 3, Your Honor.
Any objection? No. Mr. Arambula?
No.
Okay.
No, ma'am.
Plaintiff 3 is admitted. Thank you.
Thank you, Your Honor. Mr. Meyer, now to calculate the amount in arrears, would you, excuse me, when we look at the difference between the actual amortization, which is plaintiff's Exhibit 2, and the expected amortization, plaintiff's Exhibit 3, would you agree that the difference in that amount is the amount that the defendants are currently in arrears?
Yes.
Okay. So $75,640.26 minus $63,921.28. I'm not going to ask you to do the math, but that comes out to $11,718.98. Is that the amount that you allege that the defendants are in arrears on the land contract?
Yes.
And that is through the time, the monthly period ending June 14th of 2023?
Yes.
Okay. And Mr. Meyer, have you incurred any other damages as a result of the defendant's conduct under the land contract?
Just one assessment on the property.
Okay, what do you mean by assessment?
The summer taxes had a trash removal of $610.
Okay. I am going to show you the plaintiff's proposed Exhibit 4. Is this a copy of the City of Lansing property tax assessment for the summer 2022 taxes that you received?
Yes.
Okay. And the item that you just referenced, is that this trash removal $610 charge that was assessed on your summer 2022 taxes?
Yes, that is correct.
Okay. And to your knowledge, did that arise out of the conduct of the defendants at the residence?
Yes.
Okay. And does the contract, well, you are responsible for property taxes. Isn't it true that the defendants are responsible for additional assessments that may arise out of their conduct, correct?
Yes, that's correct.
Okay. And you ended up, did you end up paying this $610 assessment?
Yes.
And that was paid just as part of your property tax bill, is that correct?
Yes, that is correct.
Okay. We would move to admit plaintiff's proposed exhibit 4, Your Honor.
Any objection?
No.
Mr. Rambola?
No.
Thank you. It's
No, ma'am.
submitted. Thank you.
Thank you. Thank you, Your Honor. So, Mr. Meyer, are you requesting today a judgment for possession with a redemptive amount of, I'm sorry, $11,718.98 in arrears, $610 in other damages, including, which is limited to the trash assessment. And finally, your statutory court cost of $243.68.
Yes.
Okay. And you've also prayed for a money judgment in this case, is that correct?
Yes.
Are you requesting a money judgment consisting of the $610 in the trash removal fee plus your costs of the $243.68 that you previously mentioned?
Yes, that is correct.
Okay. And is it true that the defendants have paid less than one half of the less than one half of the original principal balance on the contract?
Yes, that is correct.
Okay. No further questions for Mr. Meyer at this time, Your Honor.
Can you give me the redemption amount again?
Yes. Would you like the amounts individually or the total?
The amounts on the redemption individually, please.
Okay.
Okay, I see it there.
Yep, the amount of $11,718.98 in arrears, damages of $610, costs of $243.68.
Okay, very good. Thank you.
Thank you.
Any
Now-
other proofs at this time?
No, Your Honor, the plaintiff is completed with its proofs.
Okay. Did you provide the court with a copy of your exhibits?
I did not, Your Honor. I'd be happy to email those to you.
Okay, sounds good. You can call your witness or you can be placed under oath if you want to give testimony at this time.
I can be placed under oath.
You raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, I do.
Okay, you can proceed, ma'am.
Okay, so October 15th, 2020, that's the date of this contract. Let's go prior, maybe about a few weeks, I spoke with a Linda Meyer, who is the wife to Stanley Meyer. She is also a relative to my children. Her and I known each other for a long time. I've known Stan as well. Linda informed me she had a home that I would possibly be interested in. Stan's buying it, and they want to sell it. And if we were interested, they would love to help us out. On October 15th.
I'm going to object as to hearsay, Your Honor.
Okay, thank you. I don't think it really goes to the truth of the matter asserted, but nonetheless, you can proceed.
On October 15th, I met with Linda, Rosalinda, in her home. I do have video of her and I and my husband with the timestamp signing documentation. It was just us three there. We completed this document. She informed me the monthly payment was no more than $700.
Objection, Your Honor.
However, it would be.
I'm sorry, but there's an objection.
Yeah, the objection is hearsay, Your Honor.
So the issue is that you're trying to tell me something someone else said, and that person's not here. Okay, where is Miss Meyer?
I mean, I'm not sure.
Did you subpoena her to be here today?
I did not know I needed to.
Okay, so it sounds like, a lot of what you're gonna tell me hinges upon a conversation with her. Can you tell me what happened without telling me what she said?
Yes, so the document here shows that it's $681 for monthly payments. So when we completed signing this document, on the back, I wrote the down payment I needed to pay, the amount that I needed, or the date I needed to pay by, and then what I would pay afterwards. So
What's that document? Is that your
this
contract?
is my contract.
You're saying that's the original one you
This is
signed?
the original contract, and this is the one I was given when I
Okay.
left that home.
Can I see that?
The original, and then I have a copy for the judge.
I want the copy. And so you're saying that this is different from what was the plaintiff's exhibit 1?
Correct.
Okay, and that's because your document says here on the second page that monthly installments would be for $681. Is that what you're saying?
That is correct. And I don't know if I can add, as you're looking at that, the signatures of notary, the notary, as I stated, I think I can use it out. So the notary of public and the witness are both the same people, which is the wife of Mr. Meyer.
Okay.
And as I was looking over this, due to this issue, I was informed of that. I did notice, and I was informed that that is an illegal breach of being a notary of public.
Okay, so you're saying that he had his wife notarized?
Correct, and that's also illegal that I looked up today, and I printed that off as well.
Interesting. What did you print off?
Well, it's just from the Secretary of State, I'm sure you know, but that it's illegal to notarize for your spouse or any other, family members.
Give me what she has to. Any other evidence you want?
When it comes to the taxes, yes. I received this letter in the mail. It's basically saying that Mr. Meyer was trying to exempt out of the taxes for the 1118 Ballard Street, and he was denied because he is not a resident of that home. So I do have a copy for you.
I'm sorry, repeat what you said.
So I received this letter from the city assessor's office. It's basically saying the affidavit was transferred, but it wasn't transferred. I didn't get this letter until 2022, November.
Yeah, I noticed that this wasn't even filed with until October of 2022. So that's probably why paperwork this wasn't sent to the registry of deeds. It's stamped October, at least the one that they showed, October 19th, 2022.
And then I received this denial of principal residence exemption. And when I called to ask what that meant, the lady informed me that Mr. Meyer was trying to write off the taxes on this home stating that he lived there when he actually didn't. So he was
I'm gonna
denied.
object as to relevance.
What's the relevance?
I mean, that for one, that paperwork, like you said, was not changed until we started this process in 2022. So for 2 years, this was under their name, but from what I was told, because again, I'm not a realtor, I'm really not too informed of all this, but I was informed that that's a way for Mr. Meyer and his wife to not have to pay certain the taxes. And so with that, also what they were doing is, now that their contract states 1050 and mine states 681, the biggest issue I have is, where has my money been going?
Okay, and I also skipped, I should have allowed you, he was under oath, you did have the right to question Mr. Meyer if you wanted to do that, okay? Did you want to ask him any questions?
Yes, Mr. Meyer, when my husband Alejandro and I were at your home signing these contracts, were you in the home while we were discussing the contract? Well, initially, were you there while we were discussing the contract?
I had to stay 6 feet away because I actually had COVID during that time.
Okay, the question was, were you in the home?
No, I wasn't, Your Honor.
Thank you. Next question.
Were, Mr. Meyer, were you, I guess, in the home at the time that we were signing the documents and you signed it yourself with us?
No, I wasn't.
Did Ms. Meyer discuss with you the change in the contract, which shows that I have a different contract than what you have regarding the monthly payments?
Objection calls for hearsay.
She didn't ask what, I'm gonna overrule the objection. She didn't ask what he said, she just asked did she. So what, he can answer that without giving us hearsay.
Can you repeat that again? I'm sorry.
Did you have a discussion with Ms. Meyer regarding this contract, which would show the difference of the monthly payments that I have and you guys have per the contract?
No, as far as I knew, the contract was for $1,050.
Okay, sounds good. Did you want to offer any more evidence at this time?
Don't think so.
Okay. Did you want to question this witness?
Yes, Your Honor, thank you. Mr. Ambula, let me share my screen again. All right, and you can see on the screen right now the Plaintiff's Exhibit 1 contract for deed dated October 15th of 2020.
Yes.
Okay. And how many documents did you sign on October 15th of 2020?
It was just this contract, and I believe I only had to sign it once.
Okay. Is this your signature that appears on this page on the screen right now?
Yes, it is.
Okay. And no further questions for this witness, Your Honor. Thank you.
Thank you. Any rebuttal proofs at this time?
Yes, I would call Mr. Meyer, Stanley Meyer, as a rebuttal witness, Your Honor.
Okay, he's still under oath. You can proceed.
Thank you. Mr. Meyer, you heard Mr. Ambula testify that she is in possession of a contract that reflects a lower payment amount. Did you hear that testimony?
Yes, I did.
Okay. And did you prepare this contract and print it out for the parties' signatures?
I drafted it and then printed off 2 copies.
Okay. And what was your intention behind printing off 2 copies?
One for them to keep and then one for myself.
So you intended to execute the agreement in duplicate, is that correct?
Yes, that's correct.
Okay. And was it your intention that both documents reflected the same amount?
Yes, it was.
And were you aware that one of the copies of the contract reflected a lower amount?
I was unaware of that.
Okay. And what was your intention as to the contract price as far as the monthly payment?
The $1,050.
And was that the number that you had discussed in your discussions with the defendants as well that led up to this agreement?
Yes.
Okay. Okay, I have no further questions for this witness, Your Honor.
Do you have any other questions for him?
I don't have a question, but comment on that. Mr. Meyer just stated that he had a conversation with us, that he signed the documents, that he printed it and gave it to us, but he also just said that he wasn't in the home and he had COVID. So that's impossible.
Okay, yeah, that's, so what you're giving is some argument, so that's fine. You're gonna have time for argument next, okay? Sounds good. You're completely fine. Okay, Mr. Mock, you can make argument if there's no further proofs.
All right, thank you, Your Honor. So this is a land contract forfeiture case, Your Honor, and what we heard was from the witnesses today was apparently there were 2 contracts executed. Mr. Meyer testified that he intended for the parties to execute the contract in duplicate, meaning both parties could have an original copy. We heard Mr. Meyer testify that, I'm sorry if I could share my screen again, testify that on this record of all of the payments made under the land contract, that there's an amortized balance due of $75,640.26. Now, the defendants didn't offer any testimony that disputes any of these payments. And we can see from the payment history, the defendants continuously making $1,050 payments consistent with Plaintiff's Exhibit 1 copy of the land contract. It wasn't until December of 2022 that the defendants made their first $681 payment under the agreement. Clearly, Your Honor, the course of performance between the parties indicates that both parties were well aware that the monthly payment that was agreed to between them was $1,050 per month. This is clearly reflected in the course of performance of the contract for over 2 years.
Okay,
Plaintiffs,
can you explain? I'm sorry to cut you off. Can you explain to me again what the loan line items mean?
yes, Mr. Meyer testified that each loan reflects a late charge. So a loan gets added to the principal, the payment gets deducted from the principal.
I guess I didn't have a question about this. Is this this flow data, is this information that's provided to the Ramblers?
I don't believe that
Well, you should probably, you can
provided.
actually client under oath.
Yeah, Mr. Meyer, was the payment history, was this specific document ever provided to the defendants to your knowledge?
No.
Okay.
Okay. Did you know that there were $50 loan payments added for late fees?
I knew there were $50 late fees, yes.
Okay. You can continue, Mr. March.
Thank you. So based on the uncontested testimony, undisputed testimony, the current balance on the land contract is $75,640.26 after applying all payments, adding the late charges that are provided for by the land contract. Mr. Meyer also testified that he incurred damages of $610, being Plaintiff's Exhibit 4, that arose out of directly from the defendant's use of the property, specifically their failure to remove trash and the subsequent assessment of a fine. And again, Your Honor, the course of performance between the parties indicates that right now, the expected amortization, the land contract balance is $63,921.28. Therefore, the plaintiff is entitled to a judgment for possession, reflecting current total redemptive amount of $12,572.66, with a writ to issue after 90 days if the balance is not paid in full. And further, the plaintiff is entitled to a money judgment in the amount of $853.68 for the damages and court costs that the plaintiff has incurred in bringing this action. We request entry of a judgment consistent with those terms, Your Honor. Thank you.
Okay, ma'am, you can make your argument. I also want you to address for me. I have a question other than the late fee. I don't think I did. You can make your argument, ma'am.
So for about a year, we made our payments, we made 1050. It was about 2022. My husband and I both had COVID. We were both off of work. Per the document of payments, there was a point where I had a lump sum that I needed to pay Mr. Meyer regarding the home due to lack of payment for a few months. Again, this was beginning January of 2022. May 2022, I paid, I believe it was $1,500 that was owed to them. $1,500, I paid that on May 21st. After that, I informed Mr. Meyer that, well, first of all, I would no longer be speaking to his wife because throughout that time, there were issues with her and I harassing me regarding payment and what I was doing in my spare time. So I informed him I would no longer be speaking to her. This would only be with him. I will still continue payment through Michigan State Federal Credit Union. That's where all the payments were being made. So I do have documentation of all my payments to them. So I told him I would still do it that way if that worked for them, but I will only be paying $681 as due to my contract. I wanted to go back to what was there.
Why were you paying $1050?
Because I was informed, if I can say this, I was informed by Ms. Meyer that because she was helping me and my children. She's
No, I want to know why she's paying $1050.
She's related to my children. And I'm not with their father. So one thing she was helping me do is just have a home for my children. It's middle of COVID. She said the best thing to do is to pay more, especially if we're going to buy this house. She said, you never know what's going to happen. And especially reading the document, it says that we are responsible for the interest and the principal. So it's best to pay extra. So that way, if anything were to happen, we would still be in good standing, or towards the end, say we pay off fine, we pay everything fine. We have that money there for the interest and the principal that needs to be paid at the end. It was like an escrow is what she called it. So once May happened, I was denied that I could pay the $681. So I asked for documentation, just like they showed, that shows their mortgage loan. And I was informed I am able to ask for that because I am helping them pay their mortgage loan. So I am liable to find out where my money is going. That is the first time I've seen a document like that. The only ones that they gave me was something typed up, which technically I have the same information per my date. So nothing was different. There's no discrepancies, except the fact is, where's my money going? All the money that the $681, the extra maybe $300-400, where's that money going? I have not seen anything until.
And you made a request for that?
I have.
Okay. Any other argument?
And then one more. So when I received this letter from the city assessor's office, I was talking to a lady about the deed, and she informed me that it was odd that the date that I signed this deed was October 5th, 2020. However, Mr. Meyer did not technically own the home until November 2020. And then the paperwork wasn't submitted to the Office of Deeds until December 2020. I wish I had that paperwork. I talked to the office of the assessor's or the deeds office about that. And that's what I was informed for almost that month. It technically was not owned by Mr. Meyer.
Okay, so that information, I don't know that it's necessarily relevant. I don't even know that you have enough to support it, because what you're telling me is hearsay.
Okay.
But if it's what you're saying is true, then that maybe you have an action for counter suit. I don't know.
Okay.
But any other argument as it relates to this?
I don't.
Okay, and so you were addressing something from the city assessors that for the trash assessment, or?
I haven't even received a letter for that. They've been telling me, Mr. Meyer's been telling me you owe $600 for trash.
That's not a letter from the city assessor for that?
Not for that, no.
Oh,
This
okay.
is just saying that the property transfer affidavit has not been received by me, and this was November 2022.
I didn't see that.
I have a copy.
So this has something to do with the trash, though, correct?
It does not. No.
Okay, sounds
And I
good.
never received any payment request or besides like a text or an email saying that I owed them for that. But I haven't received an actual bill.
Okay, any additional argument, ma'am?
I don't think so.
Okay. Here's the concern that I have, and Mr. Marsh, do you have any re-argument?
Just very briefly, Your Honor. Well, although Ms. Arambula testified that, or stated in her closing argument that she was just trying to pay ahead, Your Honor, as Exhibit 2 shows, Your Honor, these $1,050 payments are month after month, and even some months, for example, June of 2021, she paid $1,100, presumably to account for the $50 late fee. Again, in October, when she appears to have been late on the September payment. So again, Your Honor, the payment history is undisputed, and it's evident that both parties were aware that the contract amount was $1,050 per month.
Well, if you can keep that up, because these are exhibits were not admitted to me, so I gotta be able to see them.
Yes, Your Honor, thank you.
And did you give her a copy of these?
No, I did not, Your Honor.
Exactly. So this is all we got, and I don't even think can you see that, ma'am? Okay.
Very small.
Okay, and so I do see there was a history, almost majority of time of payments of $1,050. There was some times where she paid $1,100. I see something for 900, something for 200, something for 900, something for 400, something for 500, something for 750, something for 300. So she wasn't always paying the same amount. The concerns that I have are multiple. Number one, the contract that you have shown, I don't have that. Can you put that back up?
Yes, Your Honor.
Okay, the contract you've shown looks identical to the one that's in the court file that was filed with the paperwork. And I compare that with the file that she has, or with the one she has. The fonts in both of these are identical, except her copy is clean. This copy that you have is a photocopy or scanned copy of some sort. I'm not sure what's going on there, but her copy is clean as if it was presented to her in this form. I have no reason to believe this copy was in any way altered by her or anyone else. I believe she was presented with this copy. That's number one. The other issue that I have is the notary issue. Your wife can't notarize for you. That's problematic. And no one addressed that. And he stated, your client, your plaintiff stated on the record, he was not present when she signed the contract. Therefore, he's not in a position to testify what she signed to. He was not present. And the person who notarized was his wife, and she was present, and she's not here. And then I have questions as to why it was held on to for so long before it was even filed. But the mere essence of the fact that as a notary, she knows the rules, and should know the rules, and you cannot sign for your spouse, but he had her sign, he was not present. I don't believe that the plaintiff has met their burden here. And so for that reason, I'm denying possession. let's see here. The issue of the money judgment and paying the taxes, I don't have that. Can you put that one back up?
Yes, Your Honor.
I don't think she's disputing that amount. I think she said she never received it. And it's likely could have been, it probably was received by Mr. Meyer. I don't know how he notified her, if he notified her. She also indicated that she requested for information as to the mortgage, and that was not received. I don't believe she's disputing or refusing to pay that amount. Are you refusing to pay that?
The trash?
The trash?
No, I'm not refusing.
Okay, well, a money judgment will enter for the trash. And possession judgment is denied because the plaintiff has failed to meet their burden.
All right, thank you, Your Honor.
Thank you. Can I have an order under the 7-day rule?
Yes, I will.
All right, thank you.
Apologize, my husband just texted and said his phone died.
It's all set. You're free to go.
Okay, thank you.
Okay.
Are we all set, Your Honor?
We are all set. Thank you.
Thank you, Mr. Meyer. You can log off. Thank you.
Very good. Jacqueline Johnson and Mr. Bradshaw are back. Did you come to an agreement?
We did, Your Honor.
Okay, we're back on the record in that matter. Can you please state it for the record?
Yes, Your Honor. So an installment payment order will enter, Your Honor. It will be for the amount of $100 biweekly, and it will begin on July 14, 2023.
July 14th.
July 14th, right, Friday.
Okay, Ms. Johnson, that's accurate?
Yes, ma'am.
Okay, do you have any questions for the court today?
No.
Ms. Johnson? Okay, what I will do is I will take her order that she submitted, and I'm gonna edit it so that it reflects $100 every 2 weeks, beginning the 14th. And still payments are gonna go to the plaintiff's counsel. That's correct, Mr. Bradshaw?
Yes, Your Honor.
Okay, I'll sign and date that for today.
Thank
you so much.
Have a good day. Thank
Thank
Ms.
you.
Johnson.
Thank you. Same to you both.
Thank you.
Okay, let's see. Do we have anybody here for Francis Davis? Is Francis Davis present? No. Okay, Ms. Werner?
Yes.
Francis Davis has failed to appear. You may submit default judgment.
I'm sorry, this is actually a dismissal. We had filed, but it didn't show up on the record yet.
Okay. Okay, you submitted dismissal, you said?
Yes, I believe it was sent over on the 10th.
Okay, you're all set then. Thank you.
Thank you.
You're welcome. Anybody here on behalf of US Bank National? Oh, that's Mr. Whitty. Okay. Did you speak with Mr. Rivers already?
I did, Your Honor. We were not able to resolve.
Okay, so we need to have a hearing? Okay, and then give me just a moment. Nancy Diaz?
Yes.
Okay, Ms. Diaz is here, and Mr. Pacala is present via Zoom. Did you all speak already?
No.
All this time, nobody spoke, huh?
And yes, I am present, Your Honor.
Okay, I do see that you're present and that you have a shirt on now. That's why I removed you before. Okay, can't come to court without a shirt.
Yes.
Okay, we'll get you in a private meeting room to see if you can come to an agreement. This is for non-payment of rent.
We are actually going to be moving out here within the next week.
Yep.
And then there is another family here that has not been served with eviction papers, and it was my understanding that they have to be served separately.
There's another family.
They did it.
I'm sorry. I'm on the record in the matter of Nancy Diaz versus Ben Pacala, file number 23-00980LT. And Ms. Diaz is present here in the courtroom. Is it Pacala or Pacala?
Pacala.
Okay, Mr. Pacala is present via Zoom. We were here back on April 26th. Says that Mia Rivers resides in the property with, I'm sorry, do I have the wrong file? I have the wrong file, sorry. We were here back on April 26th and we defaulted last name Jamie Rewerts.
Rewerts, yes.
That's not the person you're talking about?
No.
Okay, you're saying there's another person living in this property?
There are 2 adults and 2 children, which I did mention at the last hearing at the pretrial.
2 other adults and 2 children? Who let them in the property? Who let them live there?
Who let them live here? We
Yeah.
took them in to help them out.
Oh, okay. So you had a lease and you let some other people come in there with you?
That's correct.
It was not in our lease that we couldn't.
Oh, okay. Gotcha. Okay. Gotcha. You want to amend your complaint?
Yes, yeah, they brought in other people, they're frauds, they took money from those people, they didn't pay me, and that's one of the things. Besides not paying rent for 4 months, now, the other thing, they moved in extra family that without my knowledge, and it was 4 adults, 2 kids, a dog, a couple of cats in that house.
4 adults in addition to them 2?
No, them 2. It's 4 adults total.
Okay, let's see here. So, Jamie Rewerts and Ben Pacala and then 2 other
Yep, 2
adults?
other adults, yeah, and it's only a 2-bedroom.
What's the other adults' names?
The other adults' name are Jeffrey Brace and Alicia Keckler Brace.
Okay, you have their names?
No,
Well, just
I
give
don't
them
have.
to- Just give them to you.
Oh.
What's your name, sir?
Who
Who are you?
Her husband.
You're her husband?
I'm a witness, stuff.
Oh, okay, well, she hasn't called the witness.
Okay.
Did you want to say something to her?
Yes.
Okay, you can come up and whisper it to her, but you can't say it on the record. She may not want it on the record. Okay, did you have these other people sign a lease, Mr. Pacala?
No, I did not, but I apparently Alicia had spoken to Nancy last night and come to some sort of agreement.
Oh, where's Nancy now?
Nancy's on there. Nancy Diaz.
Nancy Diaz, she should be there in the court. I'm here at the house on Zoom.
You said Nancy spoke to the other person?
Yes, last night.
No, where's the other person?
Oh, you want to talk to them?
Do you want to speak to? You want to speak to Alicia?
Yeah, you
Just
can't.
give me 1 second,
You
Alicia.
can't tell me what their supposed agreement is. They're there. Put them on.
Yep, that's fine. Give me 1 second. I'm going to put Alicia on right now.
Who is it?
It's the judge. Wants to know about you talking to.
Hello?
Hi, what's your name, ma'am?
Alicia Keckler.
Alicia Peckler?
Yep.
Do you live in this property with Mr. Pacala?
Yes.
And you spoke to Miss Diaz and came to an agreement?
I texted her last night. I didn't come to an agreement necessarily. She hasn't texted me back.
Gotcha. Okay. And who was the other adult?
Jeffrey Brace, and we have two kids.
Oh, okay. Sounds good. So you texted her yesterday. What did you text her?
I said, I can read it to you. I said, hi, Nancy. I spoke with an attorney this morning, and she told Jeff and I that Ben and Jamie's eviction does not affect us, as we are not listed anywhere on the paperwork, nor does the paperwork say all other occupants. She suggested reaching out to you, and I let her know I already have. We are 100% willing to pay you the rent on Wednesday evening. Jeff will be home for a couple of hours around 7 p.m. and then leave again, but we'll leave $850 with me. We are, as always, willing and able to throw any and all stuff away they leave behind, talking about Jamie and Ben. Clean the yard because most of the toys back there are for daycare kids, and upkeep the property while we are here. And that is
okay. Okay, I'm sorry, ma'am.
Go ahead.
I have a text. This is the first time I've talked to her.
She read the text.
You don't approach my bank without my permission.
Oh, sorry.
That's a threat.
Sorry.
Okay, tell me what you want to tell me.
Okay, this is what, can I tell you what she texted me?
Yes, ma'am.
She said, it's Alicia. We had already given them $4.99 just recently for half the rent, as we have every month for the last year. I'm going to talk to a legal aid in the morning on my break and see if there's any resources for us. We have zero indication of whatsoever of any eviction until today. Had we known all, we had zero eviction whatsoever until today. Had we known, we would have just paid the rent all along. We were told they fell behind this month. Jeff gets paid Wednesday and I don't get a check until the 23rd. Until I called you, we were under the assumption we were responsible for the entire $850 and Jeff's check of $1,100 every 2 weeks. So yep. $850 would have been a total feasible thing to do on this payday, but getting hit with this beyond what I could have imagined. We are going to do everything we can to come up with a solution. She just dropped the paperwork in my lap after an argument about the rent this month and informed us she is moving this coming week and they be planning this. They have been planning this. I'll reach out to you again in the morning. I am lost at words. We would have never allowed this to happen.
Oh, sounds good. You got their names?
Ashley Pickler and Jeffrey, what's the other name?
Can you spell his last name?
BRACE, and that is not my name.
What's your name again? Alicia, correct?
Right, Alicia. And Keckler. Okay.
Spell your first and last name.
ALISHA KECKLER.
Okay. And you spoke to this gentleman. Did he tell you something that you wanted to share with the court? Or was that what it was?
It's just
the conditions of the part. What is it?
Just the condition, just it being just a mess.
I believe it's a mess.
Yeah.
I believe he's defrauded you.
Yes.
And I completely believe it. How much money does he owe you?
It's a total. $4,131.34.
Is that past due rent?
Past due rent.
Okay.
Yeah.
What about costs and fees?
It's 4 months of rent, 4 late fees, security deposit, and court costs, previous court costs,
4,139, and what's the cents?
34 cents.
34 cents, okay. You also sought money judgment. How much money judgment damages?
That I did not, because I haven't been able to go back until they didn't allow me access.
Or you mean that you're talking about, I'm not talking about damages as it relates to your property, just money damages. You can request to keep it pending so that you can do that. Is that what you want to do? So that you can go and assess the damage they've done to the property?
Yes.
But the issue is you got 2 people in there you have to evict.
Okay. Right.
That's why I kept asking if you had their name.
Okay.
Because you did not put in all of our occupants on any of these documents.
Yeah, because they did it without me knowing.
Right, I know they did it without y'all knowing, but lots of times attorneys or people put that on there, right, Mr. Whitty? Just in case they're dealing with people like that, scam artists, may not know who was in there. I don't know, when's the last time you've been in your property?
It's like probably the date, April 25th.
Is that when you found out there were some other people living there?
Well, I text her and I noticed that there was more people and more activity, and back a couple months, and they kept saying that they were going to move out.
Okay, so yeah, I'm gonna give you a couple options. I'm gonna give you possession judgment today in the amount of $4,139.34. And their writ date's gonna be in 10 days as it relates to the 2 individuals that you've named, one being default and then Mr. Ben Pacala. As to your money judgment, you have the right to, you did file for it, and you can seek money judgment based on what you have today. Otherwise, you might be up a creek without a paddle if you try to seek him to sue him later for whatever you think the damages is gonna be. But you determine that for yourself. You're gonna have to track him down later if you want to sue him for that.
All right.
What do you want to do?
I do want to go after the money.
Money judgment today? It doesn't preclude you from suing him later for damages to the property. You can talk to him about it privately.
What is my, Mrs.
If you want to seek money damage today, I will enter it for the amount of the past due rent plus your cost, which I would assume would be, did you have to file and serve him? Did you serve,
Okay.
did you use a process server to serve him with the eviction?
Yes.
Okay, and so we can do that today, or you can reserve your money, your money damage claim, so you can add the damages to the condition of the property if that's what you want to do.
Yes, I do.
You want to reserve it?
Yes.
I'll note here plaintiff reserves money damage.
And then the extra people the people that are living there now, do I, they're kind of trespassing.
You
Do I get a marshal still and have them evicted?
You have to file a whole brand new eviction against those 2 people.
Okay.
You have to serve them with a notice to quit, and then summons, and then get that, because you didn't, that's the first, this lady just found out. She's been, although be a fraud on the part of Mr. Pacala, she's been paying rent to live there.
Yeah, without my knowledge, so they took that money and went somewhere else.
Oh, I'm sure. Okay, so money, I'm sorry, possession judgment will enter today only for $4,139.39.
Okay.
Court cost is $166.34.
So let's do another eviction.
You gotta name them in this eviction.
Okay.
Or in the new eviction. Okay, 4, 2, 0. So you can get possession in a writ as it relates to the other 2, but you have 2 other people in there What's your plan as to serving them with the notice to quit, ma'am?
7 days.
You're gonna serve them within 7 days, you're saying?
Yeah. Unless they can come up with this amount of money or
To
if
take
they
over
can-
your to take over? It sounds like they may be looking to do that, I don't know.
Okay.
So maybe you meet
I
with
go
them
over there.
and discuss it. Maybe they're better tenants than the ones you had, but you're not gonna get an eviction with their name on it today, okay?
Okay.
So that's up to you how you want to proceed with letting them stay in the property. You have her information because she texted you, correct?
Yes.
Okay. Any additional matters?
She texted Pickler.
Okay, very good. Mr.
Gentleman Jeffrey.
Mr. Pacala, do you have any questions, or Pacala?
No, we'll be excited.
No, Jamie and I will be out by the end of the week.
Perfect. You're all set, sir.
All right, thank you, Your Honor.
Thank you. Thank you, ma'am. Sorry, you have to deal with all of that.
Yeah.
Okay. Mr. Whitty, who's ready on this matter? We're having a hearing. Mr. Dewar has a dismissal. Sorry, dismissal Trump hearings. Dismissal Trump hearings. Mr. Dewar, we're on the record in the matter of Z2 Holdings LLC versus Andrea Hanson, file number 23-00832LT, council appearance.
Thank you, Your Honor. Good afternoon. Sam Dewar here on behalf of the plaintiff.
Thank you. Let's see what we have here. Andrea Hanson? Yeah. Okay. Today was the date and time set for a hearing, and Mr. Dewar said the magic word, which was he had a dismissal.
Correct, Your Honor. Your Honor, this was the termination of tenancy case, and the defendant has informed me that she's already vacated the property. She just didn't turn in keys. She plans on turning in keys today. I have a dismissal, and under the further orders, it just says that the defendant relinquishes the premises to the plaintiff today.
Very good. That's accurate, ma'am. Yes. You moved out all your stuff and left the property in broom swept condition.
Oh, I did.
Very good. All right, well, then I'll sign this dismissal dated for today, and you're all set.
Thank you.
Thank you.
I apologize for not asking you to approach it. Slipped my mind.
I'm sorry?
I apologize for not asking to approach it. Slipped my mind.
Oh, no, I don't, you're fine, you're an attorney.
I understand.
I don't know,
It's still,
I don't
it's
know
still
the rest
supposed to
of people,
ask.
they might try to shank me. I don't know. She might be mad that she can't get an eviction, I don't know. That was good. Okay, who do we have on here? Mr. Becker, which matter are you here for?
I'm here on Walnut Park and Capitol Park.
Oh, okay, sounds good. Okay, Mr. Woody's up next, I believe. Okay, now we're on the record in the matter of US Bank National versus Thierry Rivers. Donovan Rivers, file number 23-00683LT. Appearance, please.
Good afternoon, Your Honor. Norman Whitty on behalf of the plaintiff.
And then we have your name.
Thierry Rivers.
Thierry Rivers. You did tell us at the last hearing that Donovan was no longer in the property that was your ex-husband, correct?
Yes.
You notified them that he had vacated?
Pardon me?
You notified your landlord that he vacated?
I don't have a landlord. I'm a mortgage holder.
Oh, mortgage, okay, got it. Sounds good. And he signed this with you?
He lost the property in a divorce, 2014.
Got you. Counsel, you can proceed.
Your Honor, unfortunately, we haven't been able to resolve this matter. It's before the court on an eviction following the expiration of a redemption period on a foreclosed mortgage.
Our only exhibit would be the sheriff's deed. It was attached to the complaint, and I'd move its admission. The sheriff's deed itself authenticating it to a recorded document. The sheriff deed indicates that the foreclosure sale occurred on July 14th, 2022. There's been no redemption. More than 6 months have passed. No higher court has entered an order staying the foreclosure or the eviction proceeds or extending the redemption period. Accordingly, the sheriff's deed is prima facie evidence of the foreclosure and the expiration of the redemption period, and we'd ask for a judgment of possession at this time.
Thank you. And you have a defense as to the foreclosure, or that your redemption should be, what's your defense?
All of the above.
Okay.
Okay. So I want to start with this approach that Jessica Hillier from Caldwell Banker was going to leave on my door, but I opened up the door before they could. And it's this property has been found vacant. And going to say that they were going to retrieve the property. And so what
was the date on that?
That date was January 18th, 2023.
Okay, so are you disputing that this was this property was subject to a foreclosure sale?
Pardon me?
Are you disputing that there was a foreclosure on this property?
Yes.
Okay, that doesn't show me that there was a dispute. That shows me something after the foreclosure sale. Foreclosure took place in July
14th, 2022.
Why are you disputing that there was a foreclosure?
That there wasn't a foreclosure?
You're saying there was not, are you saying there was not a foreclosure?
I'm saying that there is a legal foreclosure going on my home. That's what I'm stating.
Okay, there was already a foreclosure.
Okay, and so.
And you're saying that foreclosure was illegal?
Yes.
Did you file before the foreclosure date so that you can get in court to
my communication and action has been blocked from taking such measures.
What do you mean?
Meaning that when I was first giving notice from Try to Try, I emailed, well, I sent them through the mail notification that I did not owe this amount. I also notified Select Portfolio Services that they were illegally increasing my mortgage based on what they were saying with city taxes, that they weren't following through on a loan modification.
Okay, and I recognize you may or may not have done those things, but when were you noticed or notified that there was going to be a foreclosure sale?
I was notified on my door that there was a foreclosure sale during the process that I was supposed to be responding to Try and Try letter that they sent me. So they put the foreclosure letter on the door before they gave me time to respond.
That was before, but the letter was on your door before July 14th?
Yes, it was.
Okay, and did you take legal action in the court to stop the foreclosure, that is? Because now we're at the eviction. You're trying to attack a foreclosure at an eviction. You got to attack a foreclosure at the foreclosure.
But that's what, well, what I'm saying is I didn't have the tools to do that because my communication was being blocked and my action was.
No, the tools are the court. Did you go to the court to stop the foreclosure?
What are you saying?
You got notice that there was going to be a foreclosure sale.
Yes.
You did not go to the court to stop the foreclosure or to argue that the foreclosure was fraudulent, did you?
Yes, and I didn't get any acknowledgement back.
Which court did you go to?
I did it through, I did not know that I was supposed to go to a court. I thought I was supposed to respond to Try and Try.
Okay, so you did not go to the court and say that the foreclosure sale needed to be stopped and you needed to have that foreclosure sale stopped, correct?
No, I did not.
Okay, and so you're attacking the validity of why they went through with the foreclosure, correct?
Yes.
Okay,
and
this
also,
ma'am unfortunately is not the correct form for that. This is an eviction following a foreclosure.
So then I'm dismissing that this is misrepresentation because there was no foreclosure process done. There was nothing that identified the reason why I was showing this. There was nothing to identify that I was in a recoupment process.
A redemption period?
Redemption.
Okay.
Or, excuse me, I meant recoupment.
Okay, did you ever get any notification after the foreclosure telling you about the foreclosure and the redemption period?
No.
Okay, he has a notice, you had a sheriff's cell notice? that you have as an exhibit?
Yes, Your Honor.
Okay, did she get a copy of that?
It was attached to the complaint. Yeah.
Okay,
It
so
was attached to.
you saying you
this
never
court
received
date.
this?
No.
Can I see this, please? Thank you.
The first time I received that was when I was noticed of the hearing.
The hearing for this case?
Yes.
Okay, so you got notice that the property was gonna be foreclosed, but then you said you didn't get anything else after that?
Correct.
So for a whole year, you just waited for information, or you just, because it wasn't that close to the foreclosure sale that you got an eviction?
I was waiting on knowledge that, from what I gather with the judicial process, what I understood it to be, is that a recoupment process will begin when the home is sold. And then you are giving X amount of time, 6 months, perhaps in Michigan. I was monitoring that. I was calling the assessor's office. They don't give your name to verify, but I was making proactive steps that I would be able to be given an opportunity during recoupment. That was to then.
But so you were aware there was gonna be a foreclosure. You made contact to find out what the amount was gonna be, is what you're saying?
I made contact to see if the house was sold.
Okay.
When
the
this
notice,
lady.
didn't the notice that was left on your property tell you when it was gonna be sold?
Yeah, it said it would be put up for auction on that day, not necessarily that it will be sold. People go through, houses are put on the market for foreclosure one day and they're never sold.
Okay, so you're saying you never got confirmation that it was sold, is that what you're saying?
Yes.
Okay, what else are you arguing then?
There's a tension behind here that's that would prove that I have not been given the right information that has been blocked for me for that recoupment process. And one of them is this rekey that is in the information, this name, because she says this property has been found vacant, and so I have moved out and abandoned property. During this whole time, I also was not getting mail from my postal service. And so I then tried.
Well, you weren't getting mail from your postal service?
I have not.
So
no.
did you move out the property?
I live in the property and have.
Okay, so it was not vacant?
No, I've lived in a property for 18 years.
Okay, so that notice is what you're saying was placed on the property and it was not the truth because you did live in the property?
That's right.
And then you weren't getting your mail. What period of time were you not getting mail?
Off and on for the last 21. Since I noticed, I don't know how long it hasn't, but I noticed that I wasn't getting any mail. I'll be on and off between April of 2021 until now. And that's what I'm saying in regards to Black Communication Action, because they were actually trying to raise my mortgage during COVID.
Okay, so if you weren't getting your mail, how do you know they didn't send you something and you didn't get it?
How do they know that? How can they certify that I got it?
Well, you're telling me that you had a mail issue that had nothing to do with them.
But it does, because if they said that they gave a recoupment process, where is that information? Do you have, excuse me, do you have proof that I was given notice of a recoupment process?
I'm not a witness, ma'am.
He's not a
Oh,
witness.
can I ask, can they show that they gave me any notification of
You could have subpoenaed any information you wanted for this purpose, but you did not do that. I don't have a witness here. I'm not a witness either.
Okay,
You could have called a witness or you could subpoenaed records. But he's right, he's not a witness.
That's right.
And so, but you told the court just now that you have been having an ongoing mail issue that predated even this foreclosure.
Specifically with the mortgage.
Yeah, but you say you wasn't receiving your mail. From 2021,
specifically
April.
Specifically with my mortgage, and I was not identified. I did not even identify to. I was able to pay up in October of 2023. What I had fell behind on.
So you're saying you weren't having? You're changing it now to you weren't having a mail issue. It was just mail about your mortgage.
Yes, specifically about my financial security and material reward. Specifically about that.
Okay, because that's not what you said the first time. You said you were having a mail issue. And you weren't receiving your mail.
Specific,
okay.
That's exactly what I mean.
Okay, so you weren't receiving Would you meant to say you weren't receiving any information or any mail about your mortgage from April 2021?
Yes.
Okay, because that's different. I'm thinking
Oh,
the
okay.
postal service is not delivering your mail. That's what it sounds like you're saying.
You're to be specific.
Okay.
With the mortgage.
Gotcha. Okay. Now we're on the same page. So your belief is that they were withholding information from you. Is that your
Yes.
belief? Okay. And then what is the other evidence or other disputes you have?
Other evidence of, because I want to be specific. This is me saying that I have not been given the process of the recoupment, Okay. And so, this was sent to me February 17th, 2023 from Try and Try. That also clarifies the information that he said what he has that they were asking me to evict. They said 10-day notice to vacate on this specific notice to vacate property on February 17th, 2023.
Okay. I hate to stop you. You have a lot of stuff there, but the reason why I have to stop you is because the same reason I said from the beginning is that you're attacking the actual validity of the foreclosure, and this is the incorrect form for that. You need to have attacked the foreclosure in another form, in another court. What you need to do now at this point, because this is an eviction, and you're not giving me anything that can stop this eviction, because what you're telling me is that, well, the foreclosure shouldn't have happened. Well, you need to now go and file injunctive relief, and if you believe you have evidence to support a fraudulent foreclosure, then now you have to go after them and sue them. You never did anything to stop a foreclosure, though, or to put forth any information before a court to get a foreclosure to be stopped. So the foreclosure went forward.
It did.
Yeah,
it did,
the foreclosure happened.
Yes, they put a notice on the door saying that a foreclosure will happen on this exit date. Yes, I was.
Yeah, the foreclosure happened, but you never did anything prior to the foreclosure happening, or even within the proximity of that and the redemption period to go into the court to say, hey, I'm a victim of fraud, or this shouldn't have happened. That didn't happen. But now you're being brought before the court by them because now they're trying to liquidate the property, and you're trying to use the liquidation process to now attack the foreclosure. You had every right to file for an injunctive relief or whatever relief you felt necessary to stop the foreclosure during that period. You still have the right to seek some relief if that's what you want to do as it relates to whether or not this was a proper foreclosure. But this is not a case about foreclosure. The foreclosure documents happen. I have the records that show that it happened.
That's right.
So now we're talking about the eviction, and you're not giving me anything that can preclude me stopping the eviction. If you had to went and say, you know what, Your Honor, the foreclosure happened, I disagreed with the validity of the foreclosure or how it was handled, and so I have proof that I filed for injunctive relief, and now this is tied up in the courts as to whether or not this was a valid foreclosure, then guess what? I can probably stop my eviction. But now you're not giving me any of that. You're just yeah,
I'm following you. And so when you're giving notice from the mortgage owner, the mortgage holder, and you're thinking, oh, because only information that I ever received in regards to stopping a foreclosure would be pay off everything, or your mortgage company who sent me a response to when I was asking for mitigation. They sent me a piece of paper saying I didn't qualify for not one program, not even how you could pay this part of monthly payments, maybe have to be higher than whatever. They said I didn't qualify for any of that. And so what I need to know here is, so that's my defense as far as all of this is wrong. Every bit of it is wrong. And so to be quiet, ask you a question, a recoupment process starts when someone buys the property, correct?
The redemption, this, your recoupment, you're talking about the redemption period?
Recoupment is when you have enough money that you can buy your own property.
Buy it back.
Buy it back, right?
Yeah, that's the redemption period.
That's what?
That's what he's referring to as the redemption period.
Okay, I thought that somebody had to physically buy the home.
Who's somebody?
A
If
person.
foreclosed on it, the bank could have bought the home.
Buy the home back?
Yeah, that happens often with foreclosure sales.
Okay, and so there's not a person on that deed?
It doesn't have to be. A foreclosure sale doesn't have to mean that the property was sold to a person. And most commonly, it's not sold to a person in a foreclosure sale.
Okay, so is there there's not anybody who's not a sheriff on that deed presently of my home?
I'm sorry?
There's not a person who's a person whose name is on the deed?
That's a physical owner of your home, is that what you mean?
Yes, thank you.
No one on this deed shows that they're the physical owner. This is a deed showing a sheriff's sale.
I'm saying currently.
Just so we're clear, if the sheriff's sale, nobody else bid, so US Bank credit bid, it's dead, which means it was the highest bidder of the auction. It bought the property and the sheriff executed the deed to US Bank, evidencing its purchase of the property at the foreclosure sale.
If this was not sold to another person, is that what you're asking?
Yeah, that is.
No, this wasn't sold to another person.
I'm also feel as though that I didn't even understand what this hearing was about.
This is for an eviction, ma'am.
Yeah, and so now I know that, but I would have did a defense to the eviction because I only have the proper.
Well, you were served with an eviction, ma'am. You were served with a notice of eviction.
Yeah, but it's
and a hearing for eviction.
As though somebody's the landlord when I consider myself a homeowner, thinking that I'm coming in here about to prove that I've been illegally foreclosed on.
Well, it just says defendant. It doesn't necessarily say landlord. And your notice to appear, but you were served with a summons as it relates to the eviction. You appeared for a pretrial as it relates to eviction. You were given an opportunity to get counsel, which if what you're saying you believe to be true is that you were a victim of a fraudulent foreclosure, you might need counsel. Because I don't think you don't want to go, and probably you're not equipped to go up against banks as it relates to a foreclosure.
So for clarity, so I know when I do my thing about the illegal foreclosure, nobody has to send you a notification that you're in a redemption or recoupment process. That doesn't have to be done by law.
There was information, I thought he said, provided about the redemption period that you didn't redeem the property during that time frame. But you said you weren't receiving mail.
Can I see what you have?
He's not a witness. You can't see.
Okay, so I'm saying that's my defense to an eviction process is that I wasn't given the recoupment/redemption process. That's what I'm saying. That's my defense. I was not notified of a redemption, and that seems like that's something that would be certified or something.
Correct, but you were notified that there was a foreclosure.
Okay, that's important. But what about the redemption process?
Following the foreclosure is the redemption period. And you were given the date of the foreclosure sale.
Wait, I wasn't given the date of the foreclosure sale until this hearing. I was given a notice.
You told me there was a notice that was placed on the property.
To notify that eviction, to notify that your property was going into foreclosure. That's the paper I'm talking about, the one that they put on your door. That's the paper I was never given a paper that said I was in foreclosure. No, I'm talking about the one that I was speaking of the one that I tried. I sent you saying if you believe you owe this debt, whatever, and they put that on my door before before the time was up in those 30 days. That's what I'm speaking of. I've never been given a notification of a foreclosure.
Okay.
Yeah, Your Honor, I don't have my copy of the sheriff's deed, but I'm pretty confident because I've done enough of these. If you look at the affidavit of posting and publishing, the affidavit of publishing has the notice that would have been posted as well. And I believe that sets forth both the date and time of the foreclosure sale and the redemption period, because the redemption period could be either 6 or 9 months under the statute. And so it establishes what the redemption period is in that notice that's served at the time that the property is posted.
Okay, and it says on here, date of notice was June 9th, 2022. Pretty good. Here, I remember.
And just a little further, Your Honor, just so that there's some clarity, maybe this answers some questions. After the foreclosure sale, the deed is recorded. It's a publicly recorded document that can be accessed through the Register of Deeds. And the statute further provides that a party whose interest is foreclosed has the right to redeem by going to the Register of Deeds and tendering the appropriate redemption amount as fixed by statute, based on what's stated in the sheriff's deed. So the defendant had every right to simply go to the Register of Deeds and redeem.
It states here, ma'am, in the affidavit, that the sale was 10 a.m. on the 14th of July, 2022, at the Circuit Courthouse in Ingham County, which is exactly the form you would need to go to attack the foreclosure. This is not the Circuit Court, ma'am.
I understand that. On June 18th, when I called, in regards to that rekey, I'm gonna rekey your property. I was told that there wasn't a recoupment process that had started on January 18th, 2022.
And those are probably things and evidence that you probably could use when you go to, if you go to the Circuit Court. But as it relates for the eviction, you're not providing me anything to stop the eviction. You're providing me something to attack the foreclosure. And again, that was supposed to be attacked at the Circuit Court. You gotta go attack this foreclosure. This is not the form for that. It's the wrong court. This is an eviction
I
proceeding.
get that now.
Okay.
But what I'm not getting clear on is, I was not.
I get it. You should seek counsel.
Is a
You should probably talk to an attorney, because you're trying to navigate a process that you're not understanding.
I have a attorney. Thank you.
Okay, with that being said, a judgment for possession is going to be granted because of the lack of the ability to provide me a plausible defense whereby I can not grant possession to the plaintiff. What's the right date? What date will it be? 6/23/2023. Have any questions today, ma'am?
I do not.
Okay, any additional matters for the record, counsel?
Nothing for Your Honor. Thank you.
Thank you. Okay, there's that.
Thank you, Your Honor.
Thank you. Let's see, what is this?
So do I need copies of receipts for money orders showing payment that was made on May 7th?
This is Morris's file.
Mm-hmm.
Thank you.
Number one, is escrow waived based on what was shown?
Yes,
Okay,
thank you.
Thank you very much.
No problem. Mr. Bronson is here. Do we have David and Anita Cabell here? That's you. Did they meet?
Yeah, they can consent judgment.
Okay, we're on the record in the matter of Twin Oaks Meadows versus David and Anita Cabell. File number is 23-00694. Council appearance.
Good afternoon, Your Honor. Todd Bronson on behalf of Twin Oaks, and I did have a chance to discuss this with the Cabells, and I believe we are in agreement on the amount of rent, and I'm hopeful we can go forward with a consent judgment, Your Honor.
Okay, so are you willing to enter into a consent judgment? Is that what you all discussed? Yes. Okay, so in order to enter into consent judgment, there's a couple of rights you would have to waive. One is that you have the right to be represented by counsel. You were advised of that right at your pretrial back in April, but you've appeared today without an attorney. So Are you waiving your right to counsel today?
Yes.
Okay. You also have the right to have a hearing or a jury trial if you demanded a jury trial in this matter. Did you want to waive your right to a jury trial or a hearing in this matter to enter a consent judgment?
Yes.
Okay, what's the amounts, Mr. Bronson?
$1,412.42 in back rent, Your Honor. Legal cost, $194.77 for a total amount due of $1,607.19. And I would ask permission while the Cabells are present to sign their name to the bottom of the order if they are in agreement on this.
Are those amounts accurate for you?
Yes.
Okay, and so what's the writ date? Is the standard writ date?
10 days, I believe, Your Honor.
Okay, so you're agreeing, Mr. and Mrs. Cabell, to pay the amount of $1,412.42 plus cost of plus cost of $194.77 for a total of $1,607.19 on or before June 23rd, or you're gonna vacate by that date, correct?
We've already vacated.
Okay, so you're gonna pay that amount by that date?
I'm unable to pay it by that date.
Okay,
I said I would do half in July and half in August, the first week of each month.
but you've already vacated the property?
Yes.
Yes.
Okay, when did you vacate?
The last day I was at the property was yesterday.
Okay, and did you turn over the keys?
No.
Okay, is the property completely vacant and broom swept?
Yes.
Yes.
Okay.
It's in.
Okay, well, why wouldn't there be a dismissal if they vacated the property?
Your Honor, I was unaware the property was vacated until she just mentioned it. I knew they were in a process or discussing the issues with the property manager that they would be moving out. But as of the date and time for the meeting today, I was not aware that they had moved.
Okay, you never notified them that you vacated the property?
The manager of the property, he knows that I vacated.
His first name is Terry. Manager.
Oh, okay.
He knew we was.
Okay, they said that the manager knew that they had vacated.
Okay, Your Honor, I believe he's in the meeting. We can ask him, but if they have vacated, Your Honor, we can file a dismissal. I'm fine with either.
Okay, I don't see the manager though. Let me see. Let's see. It's just, oh, he is there. Witness for Twin Oaks. Okay.
Terry Reed.
Were you, Mr. Reed, can you hear us?
Yes,
Okay, you were aware that the Cabells vacated the property?
the Cabells have been in the process of vacating. I think they may have, this is the first I've heard they've officially vacated as of now. Tried to call them this morning. I know they plan to be vacated today, so
Okay.
we will accept that they
any-
have vacated the property.
Okay, is there any way to confirm that? I can reset this 1 week or so you can confirm it.
No, we've already confirmed it. We've been in there today a couple times, so they're good.
So they did vacate?
Yes, they're vacated. We just don't have the keys.
Okay, you're gonna turn the keys in today?
We have to find the keys. I don't know how they got lost, but we have lost.
Your Honor, if I may.
So many.
Yes, you may.
Okay, we will accept that if they acknowledge that they don't need to turn the keys in and they vacated, we'll just change the locks because I know they lost the keys about 3 days ago.
Okay, sounds good. Okay, Mr. Bronson, you're moving to dismiss?
Yes, Your Honor, we'll submit it.
Thank you, you're all set.
Thank you, Your Honor.
You're all set, thank you.
Excuse me, Your Honor.
Yes.
Those keys have been we have the craziest time with those keys.
Yeah, it sounds like he was aware, but he said you're good.
Okay.
Okay?
All right.
Thank you.
You're
Thank
welcome.
you.
You say you vacated the property, ma'am?
Yes, can I tell you,
When did you-
my neighbor up over me, I put a lawsuit in with you, back in 2021, the end of 2021. Due to I went to Sparrow.
I remember now.
And I was going through a difficult time. God showed me 2 months ago what was going on. My neighbors up over me been doing some unnatural, ungodly things to me. I believe in God. I went to church. My grandmother grew me up in church. And I don't believe in a lot of demonic things, like they practice in different things that's not natural. I don't know just what all it is that they practicing, but they've been doing some things to me. And so I went to the office, talked to Victoria at least 2 to 3 times, and I just can't make headway. So I just went on ahead and moved. And so I'm trying to see, I paid the court costs to Victoria. I also paid the late fee to Victoria. I paid May's rent to Victoria, and this is the June month rent. My stuff is
Okay,
out
let me
there.
stop you. When did you move out of the property?
The weekend.
It's completely empty?
It's completely empty,
Okay.
swept out, cleaned out.
Okay. Mr. Becker, can your client confirm that?
Is this Miss Walker, Your Honor? I think I couldn't hear the
Correct.
first one. Is it Miss Walker?
It's Miss Walker.
Yeah, I do have a representative here from Central Park, right here, Victoria. You there?
Yeah, she's here.
I'm here.
Can you confirm that she's vacated?
Yes.
Not you, no, we're talking, ma'am, we're not talking to you. You're talking to someone on the screen.
We're having trouble
We
with your
can't hear
audio.
you.
Heard you for a split second and then your audio went away.
She probably has to change her speaker. In the meantime, did Kenaziana Lewis appear? Default. Mr. Becker Lewis has failed to appear.
Would request
15.
default judgment possession that matter.
You can submit default. This says no service. What is this? It's not on my
Did
document.
email a default judgment this morning, Your Honor.
Oh, we have a default.
Proposed judgment, actually. I did not check the default box.
This must have been removed from my document because I don't see it on there. That was already dismissed. Thank you.
Victoria, can you hear me? Can you confirm that Miss Walker is vacated? Can you say, can you nod your head?
Yes or no? We just need a nod or shake.
Vacate. Has she surrendered the keys to you?
She has the keys here.
Yes.
We don't want the key. You got to give them the key, ma'am.
Okay.
Yep. So what I'll do, can I reset this in 1 week and then she'll bring you the keys?
Certainly, Your Honor. As soon as we get confirmed that we have the keys, we'll submit a default without.
The dismissal?
Yeah, I'm sorry. Yes, a dismissal. Sorry.
And would they prorate June month?
Victoria, as soon as
Dismissed.
Oh, nothing. Okay. Thank you.
21st. You gotta turn that key in.
I will turn
Today.
it Today, okay.
What time does the office close? Victoria, raise your finger up so we can know what time she's gotta get there. 4, 5? There's
Show
no
us in your
office
hands.
hours today. She said no office hours today?
Ms. Walker, would you turn it in by the end of the day tomorrow, please?
End of the day tomorrow, Did she want me to drop it in
She's
the
gonna-
drop box?
Is there a drop box that she can drop the key off in? Oh, so she can do that today,
Can I
then,
do it
correct?
today? Yeah, I can do it no sooner.
That's it's just a fob? Get it, you got an envelope?
I don't have an envelope.
You need an envelope,
I
ma'am.
will.
Put it in an envelope, seal it up.
Okay, and I can drop it off
You
today?
can drop it off today, put your name on it.
Thank you so much.
Thank you.
Okay. And will I come back and say it won't be?
If you drop that off today, they can file the dismissal and then you will not need to come back, okay?
Okay, I'm gonna do it right now.
Thank you.
Thank you so much. I'm gonna give an envelope and can go straight there.
Ms. Walker, hold on, I still gotta use photos, hold on.
Oh.
Thank you. I think that's all we have.
Just to confirm, Your Honor, we are going to adjourn Ms. Walker 1 week pending the dismissal.
Yep, we set it for next week. June 21st at 1:30. At 1:30.
I'm sorry, I'm still having trouble hearing you. The 6/23?
Yep, June 21st,
Like first, okay, at 1:30.
1:30.
Does the court have the proposed judgment that I emailed this morning? Or do we need to send a formal?
Oh, I signed it, didn't I? I signed the proposed judgment. We don't have a default form though.
Okay, I'll have a default sent. Thank you very much.
Thank you. Trish?
Yes, Your Honor.
Okay, you're waiting for the 3:15 for Lewis. There was a
Yes,
failure
ma'am.
to appear. They failed to appear, so your attorney submitted a default.
All righty.
Thank you.